In 1932, President Herbert Hoover had a Supreme Court vacancy to fill. The legal community held its breath. Surely this time, the most celebrated judge in America would finally ascend to the highest court. They were wrong. Learned Hand, arguably the most influential judge in American history, would never become a justice. Consider the irony. Today, law school casebooks feature numerous opinions by this lower court judge, often alongside those of Supreme Court justices. Constitutional scholars rank him among America's greatest jurists. Justice Felix Frankfurter claimed Hand was the modern judge who has the most exacting standards of what comprises a judicial opinion. So why does a judge who never reached the Supreme Court cast such a long shadow over American law? And what can his peculiar path to legal immortality teach anyone interested in the law? Born Billings Learned Hand in 1872, he preferred his middle name, perhaps sensing early that memorability matters in the legal profession. After graduating from Harvard Law School, Hand embarked on a legal career that would span 6 decades and produce over 2,000 opinions, many of which continue to shape the law today. Hand's appointment to the federal bench came in 1909 when President William Howard Taft named him to the Southern District of New York. Later, in 1924, he was elevated to the Second Court of Appeals, where he would serve until his death in 1961. What made Hand extraordinary wasn't his position, but his approach. He combined intellectual brilliance with uncommon humility. "The spirit of liberty," he famously wrote, "is the spirit which is not too sure that it is right." In an era of judicial certainty, Hand's embrace of doubt was revolutionary. His judicial philosophy centered on restraint, not from timidity, but from a deep respect for democracy. Hand believed judges should defer to legislatures whenever possible, viewing the unelected judiciary as a necessary but dangerous branch of government. This restraint was perhaps most evident in his critique of judicial review. While most judges embraced the power to strike down unconstitutional laws, Hand questioned its democratic legitimacy, arguing it should be exercised only in the clearest cases of legislative overreach. Yet Hand was no mere theorist. His opinions demonstrate a remarkable ability to translate abstract principles into practical solutions. Consider his formulation in United States v. Carroll Towing Company, where he developed the famous Hand rule for determining negligence, B less than PL. In this elegant equation, B represents the burden of taking precautions, P the probability of harm, and L the gravity of resulting injury. If the burden is less than the probability times the injury, negligence exists. This simple formula influenced tort law for generations. Hand's impact extends beyond specific doctrines. His writing style, clear, witty, and often literary, set a standard for judicial prose that continues to influence legal writing. As he once advised, the language of law must not be foreign to the ears of those who are to obey it. Perhaps most remarkable was Hand's influence despite never reaching the Supreme Court. Presidents Coolidge, Hoover, and Roosevelt all passed him over, possibly due to his political independence or his advanced age by the time Roosevelt was making appointments. Yet Hand's opinions were so persuasive that the Supreme Court frequently adopted his reasoning. Justice Felix Frankfurter remarked that Hand's decisions were reversed less often than any other federal circuit judge who served for so long. Hand's legacy lies not just in his decisions, but in his judicial temperament. In an age of increasing polarization, his commitment to intellectual honesty and measured judgment offers a model for judges and lawyers alike. Perhaps the greatest lesson from Learned Hand is that true legal greatness comes from the humble, persistent, and intellectually honest pursuit of justice. In that pursuit, Hand remains an unmatched guide, proving that sometimes the most influential voices are those that speak not from the highest chambers, but with the clearest conviction.